As you know, a professional body must maintain discipline of its members. They all do it differently, but a common thread runs through them all: constitutionality, which leads to legality. The Malaysian Institute of Accountants, whom we shall refer to either as the Institute or the MIA, is the body that regulates and oversees the accountancy profession. A council manages MIA's affairs. Several sources of law regulate the life of a professional accountant. The first is the Federal Constitution, which we shall call Class A rules. The second is the Parliamentary Act called the Accountants Act 1967, which we shall call as Class B rules. The third are other statutory laws. We shan't speak of them today. The fourth is the common law, and the fifth are the Institute's AGM rules, which we shall call Class C rules, and the last are the bylaws made by the Council, which we shall call Class D rules. Now let's deal with Class A rules, the Federal Constitution. If any act or subsidiary legislation breaches the Constitution to that extent, that particular provision is void. Next is the Accountants Act. That creates three kinds of rules. The first are the sections in the Act. We shall call them Class B rules. And the next are the rules created by the mechanism within the Act. And we shall call them Class C rules. The fourth class are the bylaws. The bylaws are made by the Council. Now, Class A is the highest and Class D is the lowest. Let's go to Class C rules. The Act says that only the Institute in an AGM can make certain rules on specified subjects. Like what? The Act specifically defines them. There are rules on, for example, Section 7, subsection A, the regulation of the profession, Section 7(1)(k), the procedure of the investigation committee, the disciplinary committee, and the procedure relating to any complaint to any such committee. The last is in Section 7(1)(ka), the procedure of the disciplinary appeals board. Only the institute in an AGM, remember this, in an AGM can make these self-regulation rules. Why? It is because of the phrase in Section 7, subsection 1, which says the institute may at any general meeting make such rules, etc. This means the institute, not the MIA Council, regulates misconduct. Only the institute in a general meeting, not the council, can make regulatory rules. Are there type C rules on discipline? Yes, there are. They are called the Malaysian Institute of Accountants, within bracket, disciplinary number 2 rules of the year 2002. Let's call them the 2002 rules. Type C rules are special because they need to pass through these 3 statutory hurdles because Section 7(1) and 7(2) demand it. They must be tabled and approved during any annual general meeting. Second, the relevant minister must approve them. And third, these must be gazetted, published in an official government document. Are these 2002 rules valid? That depends on 3 things. First, the 2002 rules must satisfy the 3 statutory preconditions, remember? The institute in an AGM must approve them. The relevant minister must approve it. Number 3, it must be gazetted. Now, assuming 2 out of these 3 steps are satisfied, but not step 1, no approval during AGM, what happens? The answer is the rules become invalid in law. There is a statutory procedure and that vital statutory precondition has been missed. If not, any disciplinary proceedings conducted under these rules or institute rules, which if they don't pass through these 3 hurdles, can be challenged in court for lacking statutory legitimacy. How can a challenge be mounted? Well, if a subordinate legislation is inconsistent with the Parent Act, it is void to that extent. That's in Section 23 of the Interpretation Acts. The Federal Court has said that it is beyond the scope or ambit of the Parent Act. Then there's a 4th hurdle. These must be valid under the Interpretation Acts 1948 and 1967. The Act tells us how to interpret the law. The 2002 rules are subsidiary legislation. A subsidiary legislation is any rule or bylaw made under any act. Now let's apply those principles, for example, to Rules 7 and 8 of the 2002 rules. Are they valid? Rule 7 says the investigation committee may call upon any member to produce documents, and Rule 8 says if he refuses, it's an offense. This sledgehammer provision says if you don't obey, you can be convicted, fined a maximum of 5,000 ringgit, and you can be sent off to the DC. Now, true it is that a subsidiary legislation can make it an offense to contravene any rule. The law allows this. But Section 27 of the Interpretation Acts says that such a rule cannot impose a fine of more than 1,000 ringgit. So what? First, if and only if the 2002 rules have not passed any one of the three statutory preconditions, the 2002 rules cannot be enforced. Second, any fine imposed by the disciplinary committee above Rm 1,000 ringgit is invalid. Any reference or complaint to the DC based on Section 7 becomes suspect, possibly invalid. We now come to Class D rules, the bylaws made by the council. Those bylaws have a name. That's called bylaws, on professional ethics, conduct, and practice. What powers that are absent in the Accountants Act and the Institute AGM Rules seems to be made up by the bylaws. Is this legal? Well, the primary act permits this, but that is subject to certain strict preconditions. Let's examine them. The power of the council to make bylaws comes from where? Section 9 and 10, subsection A. If you read sections 9 and 10A carefully, you will see that section 9 allows the council general powers, while section 10A grants it special powers. Section 10 is the servant of section 9, and section 9 in turn is the servant of section 7. Why? Because section 7 says the MIA in an AGM can regulate the practice of the accountancy profession and the disciplinary procedure. Section 9 says the council can do all those things that fall outside the MIA's powers in a general meeting. Now, what does Section 10A say? It says the council can make bylaws to provide for all matters not expressly reserved for the institute in general meeting. Class C rules and Class D rules are like oil and water. They cannot mix. This means several things in law. 1. The council can make its own rules, Class D rules. 2. It cannot override Class C rules. 3. The council can only make bylaws in areas not specifically handed over to the MIA in an AGM. So, Class C rules created by the institute in an AGM, are a no-go area for the council. This means the council cannot make laws in a no-go area. These are areas where only the institute in an AGM can venture. So, if the council makes bylaws on disciplinary matters, then what happens? It breaches Section 7, 9 and 10 subsection A, all read together. So, we've spoken about the problems. What solutions can we offer to the institute? The institute has to go back to its AGM and ask the institute in an AGM to convert all the bylaws into Class C rules. Well, what about earlier disciplinary proceedings? Can they be saved? Can the institute call an urgent AGM? Can it ask the institute in an AGM to validate and ratify and backdate all its previous action? Well, first, the Act gives no such power to the institute, to the AGM, or to the council. So, even if 30,000 MIA members all say aye, it still does not validate an invalid section. So the answer is no. Second, the law is always considered disciplinary proceedings as being quasi-criminal. And because of that, the courts will not countenance, approve the backdating of an act and of criminalizing it by backdating. Third, the federal constitution disallows retrospective criminal law. This principle, therefore, must also apply to the accountants, councils, bylaws. So the Malaysian Institute of Accountants, I respectfully suggest, must seriously consider validating its bylaws through a properly called AGM, and if that's not possible, through a proper parliamentary amendment so as to comply with the Constitution and the Accountants Act 1967. Thank you very much for watching. Goodbye.